SJC-12454, Commonwealth versus Franklin Kapaia.
Great. Okay, Attorney Crouch.
Good morning, and may it please the court. Andrew Crouch on behalf of Franklin Kapaia, who appeals from convictions, a single conviction of first-degree murder out of the Plymouth County Superior Court. In its opening statement to the jury, the Commonwealth told them that it would prove its case through 2 points: GPS data and the defendant's own words. And indeed, that was the basis of the Commonwealth's case. But in an unfortunate effort to bolster its case on these 2 points, the Commonwealth chose in both its opening and its closing to go a little bit further. And what it did in its opening, where I'd like to begin, is 3 particular errors. And the first had to do with an appeal to emotion and sympathy, and then moving on eventually into misstating what I would consider to be key, not collateral record evidence in this case. The facts in this case are fairly voluminous, as are the multiple, the opening and closings here. But specifically, I think we can categorize them in 3 sets, in both the opening and 3 sets in the closing. And for the first set, in the opening, we're looking at an appeal to emotion. And specifically, I'm referring to familial characteristics, where the Commonwealth is going into the age of the victim, that he's 32 years old and dying, that 32 years old and he's gone. This is something we've seen somewhat frequently in cases where the decedent is someone who is perceived as being on the younger side.
More importantly than that is the discussion about the content and the consciousness of the family members.
Yes, and that would be what I would call the second category. The first one, I think, pretty straightforward. Second one, I think, as we sort of move along here, gets more and more problematic. And I think Justice Lowy has pointed out the second point, which I think is key here. And with respect to this appeal to sympathy and emotion, this is where the Commonwealth, I think, really starts to go off the rails in its opening. And it starts repeating multiple times, and this isn't just a one-off kind of statement. It's multiple times where they're talking about these horrendous and horrific final memories, not of the victim. It's nothing. This is a case related to extreme atrocity and cruelty. Some of this is going to be fair game to comment on, the circumstances surrounding the individual's death and what they might have been feeling at that time, or some of the specifics. That's not what we have here. Instead, the prosecutor is routinely, and this is the theme of the opening, continually referring to the horrendous and horrific final memories of anyone ranging from the decedent's girlfriend, to his children who are present, to the cousin, to neighbors, and eventually even is sort of a reference to the medical examiner having to do their job.
Counsel, one of the differences between this case and the cases upon which you rely to say this was an improper appeal to sympathy is that in those other cases, it seems that it wasn't at all part of setting the scene. It was just, it was definitely characterizing the victim. But here, the family was present at the scene. The girlfriend did watch the shooting, as did the cousin and perhaps the oldest child. So how do we fit this fact scenario in connection with the jurisprudence upon which you rely, where the victim's family is not around?
Well, I think one of the things we're looking at here is this is more akin maybe to the Nemec case. And I was specifically talking about Nemec 1, where it's a little bit better in terms of both the standard of review, because this was an unpreserved error, but also on the facts. As I said, some scene setting is allowed. That's what happened in the case of Alamany and others. But here, this is not what's happening. The prosecutor is focusing on almost the mental anguish, actually specifically the mental anguish that has been rained upon people who are not the victim in this case. And it's not just not their perception of what happened. It's not that they are saying that they're watching this person come in through the door and they're bloodied and shutting the door behind them. It goes beyond that. In the way that it is phrased, I think 6 or 7 times in the opening statement, they're talking about the horrendous and horrific final memories of their loved one. And this is, I think, different than the other cases we see. They are present. They could, one of them at least testifies, and there may be some fair game there. But then beyond that, we're talking about, the impact on them, which I think is what we're looking at in cases like Nemec, where we're talking about this is where we get out of bounds.
So if we could be more specific, Mr. Crouch, for instance, where you have the opening referring to the victim crawling through the back door, reaching toward the girlfriend and trying to shout, that's all relevant.
Yes.
On extreme atrocity and
Yes.
cruelty at the time of the trial, the victim's consciousness and pain and suffering was relevant. But there's a prefatory comment before that.
Yes.
Which is the victim's girlfriend's final memory was. That's the difference you're focusing on for the purposes of Justice Wedlin's question, is that right?
Yes, I would agree.
Yeah, and for some reason, the Commonwealth position is that, well, this is part of the evidence.
Yes.
Just because it's part of the evidence doesn't mean you can use it for any purpose you want to.
I would agree, and not to belabor it, but this, when you start looking at the passages that we refer to in the brief, and largely we're talking about transcript 4, 103 to about 105, 106, 107. When you read it, it's not just as Your Honor said, if it had been just a pure description of somebody walking through, coming back through the door injured, all of that in extreme atrocity and cruelty is perfectly fair game. And as we make clear in both the primary and the reply briefs, this is not that. This is, getting in here and when we start talking about, what they did, because of what the defendant did to Mr. Dillard in this attack and taking his life in terms of Mr. Myers. One of Mr. Myers' final memories will be of the defendant, pushback, screaming, things like that. Some of that might be acceptable, but when we get into I think it's 7 or 8 different things that we cite in the brief where they use this theme, this phrase, final, horrific, and horrendous memories, they're not talking about the victim. They're not talking about the decedent. They're talking about the family. They're talking about the family.
Aren't the witnesses victims also? I mean, they may not be the subject of a charge, but they were there, they were witnessing it. They're not the murdered victim, but they're certainly victims.
Oh, they're certainly, unquestionably, they're impacted by it, but this is the whole purpose of trying not to elicit, the personal impact that this has on them. That has no place in this case.
If it were a tort case for intentional infliction
correct.
of emotional distress.
Yes, this is a pure appeal to sympathy. There, when we have this case where they have these they basically have these two pieces of evidence, they're attempting to bolster that, I would suggest, improperly through this emotional appeal.
How does this give rise, given that it's an unpreserved error, to substantial risk?
I think because as I noted, I think there are about 6 sets of errors between the opening and the closing, this just being one of those sets or 2 of the sets of errors. This is, as I said, unpreserved, but I think Nemec is the case we look at for this. This is a case where Nemec was unpreserved. It talks very specific, the terms that are used, the improper terms there are similar to the ones that are used here. I think that case can provide guidance as to how this should be resolved in terms of the standard of review. The final argument, or the final statement that was made in opening that we would suggest is problematic beyond the series of 2 sets of series that we were talking about, has to do with the GPS evidence. And as I said earlier, the Commonwealth noted in its opening, the GPS evidence was one of the 2 main pieces of the case, and frankly, it was the strongest, more objective piece of evidence. The other piece, the defendant's statement, came with its own, I think, the witness himself described himself as is not particularly reliable. But here, the language that the Commonwealth, the prosecutor uses in the opening is just is not a good faith, proclamation of what is to come. And instead here, what the Commonwealth says is that this GPS location point was near to the sidewalk in the general vicinity of Lawrence Street. Okay, but then it says. It goes so far as to say, not only that, the problematic turn is not only that, it's going to show you, it's so specific and so accurate, it's going to show you that this defendant was facing in, looking in the hallway from outside Lawrence Avenue. We're going to put the defendant right there. The Commonwealth is the entity that put on Stephanie Cardacci, the probation officer in charge of the electronic monitoring. It knows the efficacy of its GPS system. It knows that it's only good up to 36 feet in terms of radius. And it knows that Ms. Cardacci or no other witness is going to testify that the person is in the hallway, looking in the hallway, the direction they're facing, the proximity. Instead, the Commonwealth forecasts, misforecasts, and frankly, it almost has to be intentional here. It can't be good faith because they know the evidence isn't going to support that. And the exhibits that you have show that it doesn't support that. But the Commonwealth makes this argument. And as I said, when we start looking at Nemec talks about kind of this cascading number of different errors. And some of them are the piece.
So I'm not dismissing that, but to sort of get right to it on that issue and the other issue, and also execution as opposed to killed for the defendant's statement. Let's go back to Justice Wendland's question and dig in a little more if you could, because this case is the defendant saying he did it and the GPS having him not at the doorway, but right there, which makes you wonder what's the purpose of all the overreaching. But putting that aside, I did it and GPS, I'm right there. How are you going to show that substantial likelihood?
Certainly. So in this case, and I will certainly talk about the closing arguments after this and how they fit in, but here, as I said, this isn't a collateral statement. The execution isn't collateral. They go to the evidence that you're talking about. Commonwealth had two pieces of evidence. Let's take them piece by piece. So the GPS evidence, that they had in this case showed that he was at or near the scene at or around the time of the murder. Again, we don't know the specific time of the murder. There are three different sets of timings here between the GPS, the cell phone and testimony of Helena Ellis, and the GPS and the 911 call that eventually led to the dispatch to the scene. We don't know how those timeframes work out, but we're looking at roughly 6 to 6:05, 6:02 to 6:05, 6:07, somewhere in that neighborhood. So we know he's at around the scene about 6:02, 6:03, then he departs the scene. Places him there, that's unquestionable. That's the extent of that evidence. It doesn't place him directly in the house, it doesn't place him in a particular place, anything more than that. It's just mere presence. So then we have to move on to the next part. And that next part has to do, we said with a 36-foot radius. The next part has to do with the defendant's single statement to McNicholas saying, "I killed him." Now, I'm not going to belabor the record, but Mr. McNicholas himself describes himself as having substantial memory issues. We go through that.
That's weight.
What's that?
That's a weight issue.
It certainly is, but when we go, in terms of, I'm not arguing in this particular section that should have been somehow disallowed, but when we talk about the impact of the Commonwealth's overreach here, it is relevant that this is not a clear-cut case where there are multiple individuals who
You're arguing substantial risk, though, and then now you get into weight. That's a problem.
Except the point that we're arguing here is that when the Commonwealth overbears on this case, and we would suggest that the evidence here is not overwhelming because there is no other forensic evidence. There's no blood. There's no fingerprints. There's this single statement to a witness who, as we said, has reliability issues. And we're not asking this court to judge those, but to keep them in mind in terms of what the strength of the overall Commonwealth's case is, which is part of the analysis we do for substantial risk of likelihood, or substantial likelihood test. This is where the Commonwealth's overreach comes in, because it has 2 points that it's pointing at. It says GPS, and it says the defendant's statement. And with the
Statements, going on a mission.
Yes, I guess there is the going on the mission part as well. It's a little less direct, perhaps, but it's certainly part of the calculus, part of the overall nature of the Commonwealth's case. But this is when I think we have the Commonwealth's this first part where we have this appeal to sympathy and emotion and how that impacts it. Then we have a direct shot at the GPS, misstating the GPS evidence, which is going to be key in the case. Then we transition into the closing argument. And in the closing argument, we have another 3 sets of issues. One of those, and perhaps the key issue, has to do with materially misattributing a statement that the defendant did not make. And the Commonwealth, again...
The execution?
This is the execution line, yes.
But trial counsel did say it was an execution, and how else would you describe it?
Well, this was, and I think the key difference here is not that the prosecutor said that this was an execution. I think under our case law, that might have been, and as we say in the brief, that might have been fair characterization. the prosecutor puts these words in the defendant's mouth, says that the defendant said, I executed, or says he executed him. Like in the defendant's own words, he executed him. Those weren't the defendant's words.
I killed him?
I killed him and I executed him are two different things. I mean, as we understand, I was.
How?
How?
Yeah,
Well, in
explain
terms
the
of,
difference.
well, under the law, in terms of, without getting too detailed into some of this, one can kill, without it being, extreme atrocity and cruelty. And I would suggest that when you misrepresent what the defendant said in a meaningful way, and again, this is one of the two key pieces of evidence in this case. When you say, I executed him, that gets the Commonwealth closer to its burden of proof on extreme atrocity
I
and
would
cruelty.
think it gets them further away, because don't people think of an execution as something quick and fast in the back of somebody's head?
I
I don't follow the logic that
Sure.
that makes the rest of it more meaningful.
Yeah, I mean, I think that may be one view of it. I would suggest that when you're I think this is a key issue, when you start talking about what the defendant actually said. And we don't have a ton of case law on this. I think the best case we have, I think, was the Pavao case, where they changed the words from get to kill. That's slightly different than.
The prosecutor had said defendant's lawyer
Yes.
said it would have
Yeah.
been fine.
I think that would have been fine. It would have suggested.
He executed him, it would have been fine.
I think yes, if the prosecutor themselves had characterized it that way.
You can't just sort of slide over Justice Seifert's question, though. I mean, yeah, he said executed instead of killed. That was not accurate. But how does that correlate to one of the Canine factors?
I think it goes into those, and as I said, where the Commonwealth has two pieces of evidence that it's looking at, the GPS and the statement. I think it's important when you misrepresent it. I think when he says I killed, my only point here is I think it just goes further. I think
You got to explain it. I mean, you can't just slide over Justice Seifert's question. It's an important point. Okay, it was wrong. He didn't say executed. He said killed, and the prosecutor said he said executed.
Right.
And I'm not dismissing the importance of that at all as far as having done it. What Canine factor does that provide a concern of a substantial likelihood
Sure.
of miscarriage of justice?
I think it goes to, I think there is more weight that can be put on the word execute than on the word kill. And I think that it goes to factors in terms of the sort of the callousness in terms of Cunene, the callousness of the defendant's actions. His interest, his desire, for suffering. There's multiple factors, I think.
I think that's the opposite. I mean, it would bear on premeditation, certainly. I'm not so sure about atrocity or cruelty. I think the issue we've got is talk about overstatement. I mean, you've got very good arguments on the GPS and on the impact on the family. The rest of it, I get the cumulative effect
Yes.
that you're trying to give us in line with Nemec.
Yes.
And that's your point, right?
Yes.
These all aggregate.
The cumulative nature of all of the 6 sets of errors, yes, all work together. This isn't a situation, as I said, where this is
Would you agree with me the strongest are the misstatement about GPS and the impact on the family?
I think so. I think in the opening, it is serious. And then, what we have not discussed, and I won't belabor with the time left, is the characterizations in an attempt to sort of reinvigorate the testimony of McNicholas. And I think these are not all in the vouching that we suggest in the brief. This isn't, as I said, these aren't ancillary issues. They're not collateral. They're key. They're the ones that the Commonwealth told the jury to focus on in the opening, and indeed the Commonwealth's case focused on throughout. But instead, the Commonwealth, we would suggest, went far afield in terms of what it did. With the brief time I have left, I just would like to address 33E. I know this court has in front of it upcoming both Robinson and Mattis case, and we obviously don't know where those two cases will lie, but the individual here was under the age of 20 years old at the time of this offense. We would ask this court to give consideration to that in its 33E.
Well, he certainly would. Depends on what we're going to do
Yes.
with those two cases. But on the facts of this, I'm not seeing it as far as a regular 33 claim.
And for the reason...
And you're not asking it on that basis. I
Well,
assume.
we would, I think the better argument here is going to be is going to be a benefit just from the resentencing in terms of what would happen for Mr. Kapaia. But if there are any other questions, I will rest on my brief.
Thank you. Okay, Attorney Nguyen.
May it please the court, Mary Nguyen on behalf of the Commonwealth. First, with respect to opening statements, I do want to emphasize that the jury instructions at the very beginning of trial, in addition to the instructions that opening statements are not evidence, immediately before the prosecutor's opening, the judge did explicitly instruct the jury that they were not to base their decision on sympathy.
You'll agree that the level of layering and the emotional appeal as to the impact on the family members went really way beyond setting the scene.
So I do comment on this on my brief, and it's the Commonwealth's contention. I think Justice Lowy picked up on the Commonwealth's argument that it was the evidence. It was fact-based.
It sounds like a victim impact statement.
So the Commonwealth's position is that, although egregious and certainly dramatic, I think in a case under the theory of extreme atrocity or cruelty, warranted, especially in this fact pattern, which I won't belabor the point, but it does involve a situation where a man is unarmed in his home and he's crawling away from the shooter, but still being shot at while crawling away.
But wouldn't the atrocity, cruelty, the callousness be accounted for if you said the defendant did this without saying, think about the impact on the family? That's the second level of that. I get the whole atrocity, cruelty, and the callous nature. If someone shoots someone in front of the family, certainly there's a callous part of that can be taken into account to aggravate the murder, but then directing the jury to essentially think about the impact that's going to have on the family members is a different. How does that figure into atrocity, cruelty?
So if I may try to attempt to answer that question, it's the Commonwealth's position that aside from what I've just spoken about the facts sort of being in, and the remarks being sort of inherent in the odious nature of the crime committed, it's the Commonwealth's position that it was relevant to establish the victim's own emotional suffering. I didn't cite this case in my brief, but a recent case is the Morse case that was recently decided. That was the case involving the so-called Mattapan massacre. In that case, the reference to one of the victims being a mother and another victim's age were proper given the extreme atrocity or cruelty theory. So although I do see that there were...
The other victim in that case was the son of the mother.
Yes. And so on that point...
Those cases deal with harm to the victim,
Yes.
not to the family members.
So there was, I did cite this case in my brief, and I think it does help the Commonwealth on this point, and that's, I believe it was the Johnson case.
I think the lesson learned to the Commonwealth should be that this kind of statement is improper, and maybe you could move on to why it doesn't create a substantial likelihood of a miscarriage of justice.
Yes, and to the extent that this court finds that it was overly emphasized, I think Your Honor is correct that the real issue is the substantial likelihood.
But on that last point, overemphasized, there's going to be other closings after today, and it's not overemphasized. It's that how the victim was feeling. Maybe the victim dying in front of his family, how the victim was feeling. In a particular case, when we had the conscientiousness and degree of suffering of the deceased, there might be circumstances, but just because something happened in the evidence doesn't mean you can marshal that fact for an inadmissible purpose. That it's episodic doesn't mean it's admissible for any purpose. So I think the lesson is more than overemphasized here.
So I want to comment, Justice Lilly, if I can, on the sort of it being unpreserved, but before I do that, one thing that I wanted to just add, though, is that to the extent that the family members were precipient witnesses to the events, you know, there is an argument that could be made with regard to the relevancy as applied to the credibility of those witnesses, and certainly Ms. Ellis's credibility and her memory of the shooting that she witnessed and the so-called trauma that may have affected her ability to observe the facts.
I agree that we should move on, sure. But because something happened, and it could be admissible for that purpose, doesn't mean you get to tell the jury about the last thoughts that they'll ever have of the victim. It's two different things. Just because it happened doesn't mean you can use it for anything in the evidence. But I agree with Justice Wendland. Why don't you get to substantial likelihood?
Are you
I'm all
to
set.
finish? Okay. Can I ask you to put put the defendant's arguments about the opening and closing in the context of the defendant's theory of the case? How did those two things work together, if at all?
So it's the Commonwealth's position, and I indicated in my brief that it didn't go to the heart of the defense, which was mistaken identity. And both attorneys, the prosecutor during the closing argument and trial counsel for the defendant, focused primarily on identification during their closing argument. So when we're talking about substantial likelihood of a miscarriage of justice, one point that the Commonwealth does make is that it did not go to the heart of the defense. And I've already discussed sort of the relevancy to extreme atrocity or cruelty, and I did touch upon and will not go into more detail unless your honors want, but the Commonwealth's position that it was fact-based and that the evidence of the brutal nature of the murder was overwhelming. I did comment on the judge's instruction. I do also want to point out that there was no objection here by counsel, and also the verdict itself suggests that the jury's emotions, in fact, were not inflamed, where they did not find the defendant guilty on the theory of deliberate premeditation. And also, on the point of, without going into sort of rehashing, you know, the issue of the relevancy to extreme atrocity or cruelty, I did want to point out sort of on the issue of prejudice in that regard. And I think I did comment on the language, but like in the Henley case, although the evidence may have been upsetting, it was inherent in the odious nature of the crime committed. And also the Alamani case, which is cited in the Commonwealth's brief. The quote is, "It is unlikely that the prosecutor's remarks had an inflammatory effect on the jury beyond that which naturally would result from the evidence presented." Certainly here there was overwhelming evidence of the brutal nature of the murder, so that the Commonwealth's, the prosecutor's remarks could not have added much to the traumatic facts that were offered in evidence.
It seems that one issue on substantial likelihood is that in Alamani and some of the other cases, there's the prosecutor begins with, this was a 25-year-old person who won't live to see 26, or whatever the turn of phrase is, and then they go on. In this case, it returns to these themes repeatedly, correct?
It returns, so with respect to the age that there were,
It's not fleeting like some of the other cases.
what was that last part?
These remarks aren't fleeting like some of the other cases we've had.
There were more references with regard I could be mistaken, but there were 8 references, I believe, to the horrific final memories or images by the family members, and then I believe 3 or 4 to Mr. Dillard's age.
Which goes to the substantial likelihood issue.
It does, and I distinguish it from a case, Santiago, that I know my brother cites, where, number one, that case was not charging extreme atrocity or cruelty, but more importantly, the prosecutor there referred to the age 17 and her condition being pregnant 5 times in the opening statements and another 7 times in the closing for a total of 12. It is a different scenario. I do distinguish that case in my brief. And then I just wanted to also bring up the Moore case, which were 8 references to the mother. So there were seven in the opening and then 4 in the closing. In this case, it was not repeated in the closing. And also, in addition to the instruction regarding sympathy, right immediately prior to the prosecutor's opening, the judge, 6 days later, in his final charge, reminded the jury again and specifically instructed that they were not to be swayed by sympathy.
Okay, before you wrap up, or I can't read the clock from here. Can you address the GPS statements?
Yes. So the Commonwealth's contention is that, like in the Texera case that I cite in my brief, the defendant has not shown that this was not something the prosecutor expected to be able to prove. Certainly, as I point out in my brief, the evidence did materialize. It may not have materialized in the way that the prosecutor, who was not the prosecutor who elicited the evidence from the GPS representative, it did nevertheless materialize, and certainly there was testimony statements that came in substantively with respect to the cousin who actually observed the shooter in the hallway. So the evidence that the Commonwealth was going to put the defendant right there, I would suggest did in fact materialize.
But not the way it was promised to the jury, right?
So, at worst, it was a mistaken belief by the prosecutor.
But why was it even a belief? Why was it a belief? That was your witness. It was the Commonwealth's witness. They should know what the person from the GPS company would say. So that seemed, it was a big mistake. It was a mistake. It wasn't a belief. Why? Why did that happen, I guess?
So I can't answer as to why it happened, but I can, if I may, emphasize sort of the prejudice, what prejudice was there, if I may. And I suggest that there was no prejudice, certainly no substantial likelihood of a miscarriage of justice, where number one, as I pointed out, the evidence did materialize in another way. But secondly, it was isolated in a brief reference and not repeated in the closing.
But in the opening, I think the prosecutor specifically said, we're not going to have forensics, we're not going to have a specific ID, we're going to rely on 2 things. And as your opposing counsel has mentioned, one key was the GPS that will show the defendant right at this specific door stab, on the stairs, facing this way, very, very detailed in a way that I can't really understand why anyone would believe GPS would be able to give that kind of detail. There just doesn't seem to be any good faith basis for that level of detail from a GPS instrument.
So what I can say is that, at least with respect to the jury being able to sort out any excessive claims, number one, the GPS representative was on the stand for quite some time, and both defense counsel and the prosecutor in closing accurately stated, this is the prosecutor, for example, during closing on page 24 of volume 8. The defendant is outside 419 Montello Street at the corner of Montello and Lawrence, and he's right outside the door. She again says at page 25, at 6:02, the defendant is right here at the corner of Lawrence and Montello, right at the murder scene. So she never repeats what the prosecutor said in opening regarding that
Well,
challenge
that's good.
statement.
That's good, but I guess the issue underneath this is that that's such a specific statement for the prosecutor to make about something highly technical, that it sounds as if he had a basis for believing that. That's what a person would think if you didn't know much about it. What is the evidence the prosecutor was basing that statement on? And that's what's kind of hard to understand, because there certainly wouldn't have been that evidence. It's just not what GPS does. So at least you've got to say it's excessive, if not intentionally misleading.
So it's hard to kind of go into the mind of the prosecutor in that instance, and sort of standing from where I'm standing, what I can say is speak to the issue of prejudice. And fortunately, the jury in this case were repeatedly instructed that opening statements are not evidence, and also that their memory controls with respect to the evidence and the testimony. So certainly, the jury is presumed to follow those instructions. So I do think that the judge's precise and clear instructions in this case.
Can you address the cumulative effect of, for me, the problematic ones, the GPS and the impact on the family?
Sure, so that, this was a case that I believe the record shows that it was the evidence and not sympathy that was the foundation of the jury's decision.
How do we know that?
I think that one of the things that I've mentioned when we're looking at the prejudice issue is the verdict. That is certainly suggestive that the jury's emotions, in fact, were not inflamed.
How did we get there?
He's sitting here on a first degree, so how are we getting that on the verdict?
I'm sorry, Judge?
He was convicted of first-degree murder.
They didn't just sit there and believe everything that the prosecutor said, for example.
But how do we know? I mean, how do we know that how does the verdict establish that there was no prejudice when he was convicted of first-degree murder?
Well, I mean, as I had indicated, the jury are presumed to have followed the judge's instructions, and here he was clear, and he explicitly stated twice that their verdicts, they were not to be swayed by prejudice.
Yeah, how long went by between the closings and the jury returning the verdict, or the instructions and the jury returning a verdict?
I'm sorry, I actually, off the top of my head, do not know the answer to that.
It was a very short trial, as far as murders go.
Yes, as far as murders go, it was.
It was like a 5-day trial or something.
So I know that the 6th day, there were 6 days. As far as the closing argument, I do have noted here that the closing argument occurred on the 6th day.
And I'm just curious, because it's in the same transcript, the verdict and sentencing, so I'm just trying to figure out if they didn't break it up into 2 transcripts for 2 different days, right?
As far as like the closing and the jury charge, the final charge?
And the verdict and sentencing. They're all in one transcript.
I don't know that about the verdict, but I do know that the closing and the final charge were in one transcript.
It'll be in the record, but off the top of your head, do you know how long the jury was out for?
I should know this, and I apologize.
We'll find it. It's easy to find.
Yeah, the jury went out to begin deliberations at 10:35 a.m. It's on page 62. And they came back at 4 o'clock.
I see that I'm running out of time. Are there any other questions? Thank you. The Commonwealth would rest on its brief.